International legal organization defending the right of artists to express, create, and imagine freely. With me today, I have Federica Erilmi, who is case officer at Avant-Garde Layers. But before anything else, I would like to say thank you very much to INSTAR and to Tania Bruguera for inviting us. We are very close to their mission and their principles of non-discrimination, anti-censorship, transparency. We do fight the same fight as INSTAR at Avant-Garde Layers, just that we are using different instruments and we are doing it from a different angle. So we are Avant-Garde Layers, so as you can imagine, we are lawyers. Our main instrument is the law. Now, for most people that are not lawyers, law can be very intimidating, all the more so for artists. Nothing more different in our imagination than an artist and a lawyer. We appear to live in separate universes, we speak different languages, we have different goals. The law is slow and conventional, and the business of art is to be ahead of its time. The law is definitional, art defies definitions. So when artists think of law, they usually think of restriction, limitation, regulation, the extent to which their freedom of expression can go, but rarely do they see law as a tool that can protect or enhance their rights. Now, this is why at Avant-Garde Layers, what we're trying to do is to build bridges, many bridges between these two apparently opposing worlds, art and law. And we are trying to democratize, in a way, legal processes for artists, to translate law for artists, to make it more accessible to them. Now my colleague Federica will tell you more about the work we do at Avant-Garde Layers, how we do it, why we do it, and what exactly and who we are protecting. But the way we have organized this conference today is that I will, at the beginning, try to set the framework for this conversation and explain some basic references relating to freedom of expression, limitations to freedom of expression, notions like censorship, hate speech, what is artistic freedom, of course, from a legal perspective. So then Federica will make her presentation about Avant-Garde Layers, and then we are going to open the space for discussion. How does that sound to you? Good. Now, before I tell you more about freedom of expression, I'm just curious to know if amongst you, if you're like artists or art curators or simple visitors, or if you're artists, Good. Art patrons, supporting art. Okay, thank you. It's good to know who our public is, so that we can also maybe adapt our talk and try to answer your questions. Now, so I will start by saying that freedom of expression is the preeminent right in a democracy. It is the right that allows us to express discontent and criticism about violations of other rights. If we can't complain about being discriminated against, being arbitrarily detained, being tortured, then we don't really have anything. This is the reason why freedom of expression is is the first right to be taken away in an authoritarian regime. So freedom of expression is a political, legal question. It is intrinsically linked with popular sovereignty, the separation of powers, and an independent judiciary. Restricting freedom of expression is symptomatic of a weak democratic system. Now, because of the importance of the right to freedom of expression, it is a right that is well established in international law. There is a tendency, however, in domestic laws everywhere to protect verbal expression primarily and only secondarily non-verbal expression, abstract expression, expression that is usually involved in artistic creations. The reason being that verbal expression is considered to be more important than non-verbal one, because verbal expression is considered to contribute to public debate, to conversation. It has a political and social import. This is the reason why political speech, for instance, is afforded a higher level of protection by the law. I'm just going to say that according to the European Court for Human Rights, it is in the nature of political speech to be controversial and often virulent. That does not diminish its public interest, provided, of course, that a line is not crossed. But I will be speaking about this line and limitations to freedom of expression a bit later. Now, I would like to explain the title of this talk, why the right to shock, offend, and disturb. Where does it come from? Now, this is what the European Court of Human Rights said 40 years ago in a decision called Handyside versus the United Kingdom. And I'm going to read you the entire paragraph. So freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population. Such are the demands of that pluralism, tolerance, and broad-mindedness without which there is no democratic society. This means, amongst other things, that every formality, condition, restriction, or penalty imposed in this sphere must be proportionate to the legitimate aim pursued. I'm ending the quote. So this is from a decision, from a judgment of the European Court of Human Rights from 1976. And look where we are today with freedom of expression. Now, because we're talking about proportionality and legitimate aim, I'm going to go into the limitations to freedom of expression. Freedom of expression is not an absolute right, so we can limit it. And I'm going to explain how the law analyzes limitations to freedom of expression. So in the law, we call this a three-part test. It is a test based on international law and standards and developed and refined mainly by the European Court of Human Rights. When we're talking about limitations to freedom of expression, the approach is, or rather the question is, to my freedom of expression, if there is an interference from the part of the state, does this interference meet the criteria that this three-part test has established or not? Instead of asking the question, can I do that or can I say that as an artist? The question is, if I now jump on this table and I incite all of you to take up arms and attack someone, and police comes and arrests me, the question and the three-part test applies to the police and not to me. Is the interference meeting these requirements? And now I'm going to explain the requirements. And this is very important for you to understand the approach to freedom of expression and that when we ask ourselves what we can say, it's already self-censorship. It should not be the case. Of course, we should be mindful of what we say all the time. But so going back to the three-part test, the first part of the test is that this interference, so the police coming to arrest me, is provided by the law. Is there a law? Is there written somewhere that I can't jump on a table in a public space, that I can't incite to hatred? That is there anywhere written that? So if it's not, then the interference, it's not provided by the law and it's not legal, it's unlawful. The second part of the test is, does it pursue a legitimate aim? Again, the interference, not the expression. Now, a legitimate aim can be national security, public safety, the feelings and freedom of others, and this is where most of the discussions happened. Because in the legitimate aim exercise, there is a balancing test that is usually done between two competing rights and interests. Like you usually have freedom of expression against the right to privacy or, as I said, national security, public interest. So you have an exercise of balancing there. And then the three part of the test is connected to the second one very much, in the sense that we have to prove that the interference, the police arresting me, it was necessary in a democratic society. What does that mean? It means that the interference must meet a pressing social need and must not be disproportionate with the legitimate aim pursued. So if public security, for instance, let's say health, general health, the health of everyone is at risk, we are balancing again here the right of the individual against the right of the society. So I'm telling you all this because it's important to understand that these are complex exercises and that the law provides the instrument for us to analyze it, to reflect about it. And when censorship happens, randomly, this is an interference to freedom of expression when you have law enforcement, policemen, or administrators of art venues or whoever decides to censor art, then we have to make sure that these elements have been taken into consideration. It's not something that can be done easily. And if it's not, then we go to court and we win because this is what the law says. Now, so I really don't want to get too technical here with this exercise. This is what judges do, what lawyers do, but it's important to understand that it's complex and that as lawyers, we have instruments to defend freedom of expression or to balance different rights. We don't say that it's limitless, but we say we need to take into account the circumstances of each particular case in order to make a decision about whether the interference was lawful or unlawful. Now, as an introduction to the notion of hate speech, I'll just like to speak about another judgment of the European Court of Human Rights, a more recent one, quite high profile because it was litigated by Amal Clooney, who I guess you all know. It is Perinček versus Switzerland, and it was about a Turkish ultranationalist activist that called the Armenian genocide an international lie. This happened in a public space in Switzerland, and as a consequence, he was convicted by the Swiss courts for denying publicly a historical fact. He came before the European Court in Strasbourg, and the court, after undergoing this three-part test I had just described, ruled in favor of Perinček. They said that his statements were certainly offensive and inflammatory, but were not perceived as a form of incitement to hatred, violence, or intolerance. So the court decided that restriction on free speech imposed to Perinček was disproportionate. This is to say that not all hate speech is unlawful or calls for criminal sanctions. And this is a very important distinction to understand. Hate speech as such does not have a definition that is universally accepted. In general, it can be defined as statements that are derogatory, offensive, harassing, and threatening that are directed at an individual or a group of individuals based on their race, color, political convictions, religious beliefs, etc. Now, these grounds are all protected by international human rights law and more specifically under the right to freedom from discrimination. Again, a well-established right in international law. Now, as a lawyer, I am not too fond of the expression hate speech because, well, it sounds a bit emotive and it's very wide. We don't understand if it's lawful speech, unlawful speech. As I have explained, it can be hate speech, but it can be protected, as it was in the case of parent check. That's why I wanted to give the example. That was obviously hate speech, but the law said you can do it. It can be unlawful hate speech. We go to court with hate speech and the court says it is true that that is speech that should not be protected by the law, so that's okay. And it can be also speech that is obviously unlawful, obviously illegal. It is when people incite to violence, hatred, or when there is an imminent threat of violence as a consequence of some form of expression. So in these circumstances, we don't have to go to court. It's obvious. You get arrested and you go to prison. So again, by labeling something as hate speech as such without making these distinctions, it's can brand those that disagree with us as bigots, and then it sort of stops dialogue and debate. And this is essential in a democratic society. It's important that we learn how to communicate to each other, how to debate, how to talk to each other, even if we have opinions that are diverse. Now, artistic freedom. The challenge with artistic freedom is that art has different means of expression. It is not straightforward. And even if it is straightforward, it still needs interpretation, it needs knowledge, it needs context. There is a quote by Flannery O'Connor that I like, which says that art never responds to the wish to make it democratic. It is not for everybody, it is only for those who are willing to undergo the effort needed to understand it. There's another quote that I like. This time comes from a US Supreme Court justice who once famously said, one man's vulgarity is another's lyric. This is just to say how subjective art is, and precisely because it's so subjective and we all have an opinion about it and we all feel something about it, it doesn't make our opinion expert or an expert opinion just because we have a reaction to it. And this brings me to my second point, which is, who are the experts who can judge art, who can censor art? And the answer is simple, it's experts. Art is a field of expertise, and those that judge it, those that judges anti-Semitic or blasphematory or obscene, pornographic, need to be experts in art. Otherwise, on what grounds would they speculate about artistic merit and motive? Now, unfortunately, judges and lawyers rarely ask for expert opinions where controversial art is under consideration. When you have a medical case, for instance, or any case where expert or technical knowledge is required, engineering or any other field of expertise, you would invite an expert to testify. You would have an expert report, you will have an expert witness. But when it is about art, you don't, this is not really the case, right? Just because it's art and we all have an opinion about it. There are court decisions that describe pieces of art like nonsense, even disgusting. You'll be surprised, but this is in the legal reasoning of a judgment at the national level or even regional level. So it is important that we have a context for the art, that we consider it an expert field, and this is already a personal fight of mine, but also one of AGL's now, that we do sort of try to make art, like recognize art as an expert field in the courts. I think it's very important that the way art is judged in a court influences a great deal the way it is perceived by you all, by the society as large. So it is important that, I'm not saying that lawyers or judges should be art informed all the time, but they should at least have the understanding that we need to call the experts to judge it when it is the case. Now, censorship of art, just as censorship of speech, should be allowed only in exceptional circumstances and after careful consideration of all the elements I just described. Ad hoc acts of censorship should not be allowed, should be taken to court. You should see a lawyer. You should ask for our support, and we are there to help you. Now, if we censor art that is controversial, that speaks of painful events present or in the past, then our beliefs, our values, our convictions won't be tested. This is why artists today are essential, and the work they do is essential because they provoke us, they challenge our convictions, sometimes our religious beliefs, our familial values. We don't understand them. why do they he's part of the performance. So why do artists do the things they do? Why do they say the things they say? Why do we have a phallus in a daisy field? Why do we have the face of a pig on a politician? So because of these questions, they sort of are sort of like stretches our understanding to its limit. And once we are at that limit, we are training this muscle of flexibility that we should all be training more today. I know there's a lot of discussion about how polarized our societies are today, and they are indeed polarized because we live in societies surrounded by people that look like us, that talk like us, that have the same beliefs, the same values. We found those people very easily today to the internet, so we have no one that challenges our convictions, really. So we sort of lost that capacity to argue and that ability to also change our mind when it's necessary. So I think that being able to influence each other through peaceful and intelligent dialogue, and this capacity to change our mind through honest and respectful dialogue is essential for our society. It is the act itself. It is the democratic act itself. It's participating in democracy, right? If we can't really influence each other on the basis of dialogue, then the alternative is some kind of violence, right? So anyway, for the important work they do, I hope I have convinced you, for this important role they perform in our societies, artists everywhere in the world are being harassed, censored, put into prison, and sometimes killed. And this is why at Avant-Garde Layers, we are defending artistic freedom and artists. We are trying to put artists on a map of vulnerable people. They are not recognized as such by the law. People do not know the struggles they go through because of the art they are doing. As I said, artistic expression is sometimes difficult to interpret, to understand. We need a context, we need knowledge. It's not like journalistic expression, for instance, but we know why a journalist is in prison because he issued that report, he wrote that article. But with art, sometimes there's no connection between why an artist is in prison and the work he did. So it's very difficult to monitor, it's very difficult to identify, but this is why we exist at Avant-Garde Layers, to sort of make some sense of it. And what we say is that we're trying to raise the legal profile of artists, right? So just one more idea before I pass it to Federica. I think at the basis of our work at Avant-Garde Layers is this conviction that artists should enjoy greater levels of protection for their involvement in matters of public interest and for inciting dialogue and debate, essential in any democratic society. So now I'm just going to ask my colleague Federica to tell you a bit more about the work we do at Avant-Garde Layers, and then we open this for discussion. Thank you. Federica, to you.
Thank you, Andra. If I could have the presentation on the screen, please. Amazing, thank you. Thank you for staying with us. And as Andra set the general framework, now I'm gonna talking a little bit more about who we are and the work that we do at Avant-Garde Layers. Next slide, please. So I wanted to start with our vision, which Andra already mentioned briefly, but this is the original vision that we had and which has led us for the past 3.5 years and is still the North Light that we follow. So we believe that artists should enjoy greater levels of protection for their involvement in matters of general interest and contribution to public debate, which is simply essential in a free and open society. Next, please. So how we concretize our vision is through these three goals. So we are using the full potential of the law to ensure access to justice and safe haven for artists which are in situation of increased vulnerability or risk. Secondly, we are expanding the right to freedom of artistic expression mainly through strategic litigation and through research. We're also promoting a collaboration and an exchange among lawyers from very different jurisdictions to encourage a culture of pro bono for the benefit of artists worldwide. Next slide. I wanted to present you the state of artistic freedom. This is the state in 2021. And as you can see, the numbers are pretty self-explanatory. We can see that 17 artists across 6 countries were killed. 82 artists were in prison in 20 different countries. 107 artists in 27 countries were prosecuted, and 133 were detained. On top of this number, I think we're all very aware and familiar, unfortunately, with the recent cases of violence and harassment towards artists. We saw just a few weeks ago the attack to Salman Rushdie, which was an insane and unprecedented attack to artistic freedom. We really think that there's no better time than now to talk about artistic freedom. And it's really an unprecedented time where artists are afraid, to speak their mind and to create that art. And we really think that it's urgent that we start the discussion. We think that freedom of expression doesn't just happen, but it is our work and vigilance of us all, starting from us here today, that maintains. Next slide, please. I wanted to talk a little bit about our approach at Avant-Garde Lawyer. We believe it's a fairly unique approach, and this is the reason why. So first of all, we are cultural rights defender. It means we are human rights defenders, but who fight for the respect, protection, and fulfillment of cultural rights of artists and creators in general. We also promote a pro bono culture. We strongly believe that money should never be the reason why artists cannot afford legal support. And to tackle this issue, we've built a global network of lawyers and experts which give their time, but most importantly, their expertise to help artists for free. Additionally, we respect art's unique ontology. This means that we defend the artist, yes, but we also defend the artistic process by making sure that the artistic intention of the artist is always accurately presented in court. Additionally, we do legal advocacy. What that means is that with each case that we with each case that we support, we aim to offer an instrument that will impact not only the single artist, the single individual, but that goes beyond that and becomes part of a broader strategy to protect and expand the space for creative expression worldwide. Next slide, please. As I said, we apply a fairly unique strategy to support artists, and we curate a specific strategy depending on the artistic particular situation. And I broke down, every case is very different, but I broke down here the 5 major steps of each case. So firstly, when artists approach AGL for supports, we conduct an eligibility test. What it means here is that we take into consideration all the particular circumstances of the case, including the artist and its profile, the risk that is exposed to, but also including any relevant information, such as if it belongs to a minority, gender, religious, ethnic minority. So we build a complete case. Secondly, we do a preliminary legal research and we prepare the case strategy. After that, AGL curate a global pluridisciplinary team which is suited for each case. So once we have defined and identified the strategy, we identify the best team to support with that and help us implement the strategy. Usually it includes local lawyers, art, legal expert, and translator. But as I said, it's really unique to each case. We then see the implementation of the case, which is when we coordinate and support the team that we have created every step of the way to make sure that the voice of the artist remain heard at every step of the way. And during this phase, there's a lot of negotiation, there's a lot of flexibility. We need to make sure that artists and lawyers are well connected. And lastly, we do follow-up, monitoring, and evaluation. And this point doesn't really doesn't only represent the end of the life cycle of the case, because it's rather an ongoing process. So we collect feedback from everyone involved, and we keep on collaborating with artists and lawyers, which continue to support AGL in different capacity, building a community that we can rely on in other cases. Next slide, please. Next slide, please. I just wanted to share some numbers. So in the past 3.5 years, AGL has supported 43 artists globally, belonging to very different artistic domain. As you can see, there's been singers, musicians, visual artists, poets, authors, and our efforts are truly global. As you can see, we support the artists in 18 countries. Just to mention some, it's been Egypt, Iran, South Korea, Albania, France, Cameroon, just to mention some. But in the next slide, I wanted to talk a little bit more about the artists that we have supported. And I wanted to share this picture because it was taken just very recently, just a couple of weeks ago. And you can see Andra Matei. For the first time, she met with Sajad and his family after being working together for 1.5 years on his case. Sajad is an Iranian musician, and due to his uncertain and precarious legal status in Albania, he couldn't enjoy basic human rights, such as the right to travel or the right to gain from his artistic activity or to freely create and perform his music. And the legal case was very complex, but AGL really supported him throughout the whole process. And we helped him to start a new life in the Netherlands with his family. And he now happily works at the university. Next slide. I also wanted to share light on 2 cases that are really important for us. As I said, and as Andra well said, AGL wants to empower the artists so that they can create and imagine freely. And those 2 cases are really the representation of that. So Terry is a graffiti artist who spray painted remnants of the Berlin Wall at the Berlin Square in Seoul in 2018 to celebrate the Inter-Korean Summit. Rami was charged with the destruction of public goods. AGL argued for the first time in a court of law that graffiti is a form of social and political commentary deserving the protection under Korean constitutional law, but also under international human rights. And this was something unique, and it was like a great success for AGL, for the artist, but also for the advancement of the in the field of artistic expression. The other case that I wanted to highlight today is Rami Assam. Rami is an Egyptian musician. As a result of his music and activism during the Arab Revolution, Rami was arrested and held in custody, where he was beaten and tortured. His songs were banned in Egypt, and he was threatened, harassed by the government, and he was forbidden to perform in any public shows. AGL managed to detangle very complex immigration issues, allowing Rami to start a new life in Sweden, where he was able to start his artistic career again. And it's really by talking with these artists and hearing their story that we realize the need to not only continue our work, but share our knowledge and our learnings. And if you can please go on to the next slide. We have created this course, this online course, The Art of Defending Artists, which is an online course meant to equip stakeholders with the knowledge and skills and tools to navigate international and regional mechanisms to defend artists' rights. It's a unique and extraordinary opportunity, and that's why we're bringing up here today as well, because you can, in this course, you can meet experts, senior lawyers, judges, UN heads of division, but also network and meet the people who are behind the big decision at this institution. So if you're cultural rights defenders or if you're interested in the field, this is a truly unique opportunity and you should sign up, and we're happy to talk about it more and to answer any question on this. Very briefly, before I conclude the presentation, I just wanted to share a thank you with the rest of the team at Avant-Garde Layers. We're a fairly small team, but we're very dedicated to the cause, and I just want to share a big thank you with them. Oh, yes, thank you, and I hope that through today you've managed to understand a little bit who AGL is. And that's it from us. Thank you so much for listening. And if you have any questions now, we're here for you.
Thank you, Federica, very much. Just to add something about, so you just saw the photos of the team, but you have to know that we are supported by a global network of lawyers and experts of over 60 people. So we are working worldwide, and we have created and continue to maintain and grow this network. These are people that give their time and expertise for free, and these are the best in the field. So yeah, we are a small team, but with big support. I think I saw a hand raised there.
Thank you so much. Very inspiring and encouraging. And I just want to mention that in human condition, Hannah Arendt had a very famous tripartite of action, labor, and work. And I think what you talk about today, because laws is about speech freedom, yes, the freedom to express or provoke something, which for the Hannah Arendt tripartite is pretty much about action. But I'm also curious how you think about the labor issue, which I think is very important in art production contemporarily. For example, for a huge installation, sometimes the art is kind of work. I mean, artists kind of work as a manager, project manager, but didn't really like pay a good fee for the worker to really build a huge stuff. Yes, and in, for example, curation, even Documenta such an event like this, it's actually not just involve very creative artists, but also, for example, workers, yes, cleaners. I mean, people taking care of the whole thing. Yeah. Which is also related to action in many other ways. For example, Hannah herself also talk about the labor movement, I mean, in 19th and 20th century. Yeah. So I just curious how you think about the labor issue in art. And is that also some cases you will have concern of and probably do something? Thank you.
Thank you very much. Just to make sure I understood correctly, you're talking about people that are involved in the creation of an artwork and that labor towards creating that artwork, but not the artists themselves, but some additional stuff.
It's also like a more general question to think about the labor dimension in art, not just production, but also, for example, a review, write a commentary for free. I mean, sometimes in China, these things happen a lot. Yeah, because art is pretty much a site that fame function as capital. Yes. And also in some more concrete way, for example, labor relation sometimes is very vaguely defined. Yeah, in art.
Yes, thank you. Well, I think it's a very good question. At Avant-Garde Lawyers, we haven't had to deal with issues like that. We mostly focused on censorship, free expression, but obviously, labor should not be for free, and there is a right of the artist to gain from the work that he does. So this is provided by the law. This is in international treaties and conventions, and it should be in two-party contracts as well. So I don't think work should be done for free, if that is the question.
Okay, thank you so much. And hopefully in the future, there could be more done in the labor dimension.
Yes, we would. I mean, we'd be happy to take on a case that deals with this matter in more detail, maybe. Thank you.
Yeah, I'm interested in my rights as an individual, not just as an artist. I believe that I have been defamed in this process. Like this show has been written about as being anti-Semitic, the whole show. So that, to me, that means that includes all the artists, not just the curators, but the artists as well. Now, I believe that's defaming us by calling us all anti-Semitic. That telling the public that this whole show is anti-Semitic. I want to know if I have a case to take the media to court, to take the state of Hessen to court, to take the city of Kassel to court, to take the state of Germany to court.
Of course you do. You can take everyone to court.
Yeah.
You can take all of them to court. The thing with defamation is that it is, as I said, it is linked. It is directly linked to freedom of expression as well. So you, in principle, you have the same tool that they have. You can write yourself an article and just argue against what has been said in the media. But there is a limit to defamation. If you feel that it touches your personal life, that it has an impact on the way you gain your money, or on your work, on your mental health, on anything else, then going to court it's the option.
Yeah.
So you have two tools if you want. Yeah.
Okay. See, like I believe that this can impact negatively on us, on we the artists. Like there's a lot of Jewish people in the art world. Like who might believe, if they believe what they're told in the media, that could seriously impact on us, because there's a lot of Jewish art dealers, a lot of Jewish art collectors, So there are real consequences here. They may just get together a list of all the artists who are in Documenta 15, and just say, okay, we're not dealing with these people.
Of course, this is a very important circumstance to be taken into account. This is how I, in the end, assess if in the end it is defamation or not, or if it is a criminal act or not in what, in the accusations that were brought to you. I don't know the specific details of your situation, but yes, it sounds...
It's all public. It's been printed, already.
Yes, yes.
They've printed lies, straight up lies, and they didn't do their job, which is to investigate. They didn't investigate. They just printed lies. And those lies affected us. It affected the curators. They've been under pressure for since January, when the lies first started. But this white-handing has happened since Ron Grupper was announced as the curators of Documenta 15. Now there's a pattern here.
Are you talking about the famous scientific committee and the report they issued?
They're just a recent thing.
Yes.
A recent invention. They came up with this name, scientific. There's nothing scientific about their report. If it was, it would have been peer reviewed and it would have been shut. They'd have told them, no, you cannot put this. Yes, in my opinion.
No, I agree. And this goes back to what I said at the beginning of this conversation, that in order to assess art or to censor it or to do whatever it is with it, you need to take into consideration all these elements I had described at the beginning of the conversation. These are not decisions taken lightly. So if you have a scientific committee, then these scientists have to be experts for real, and they should do a proper assessment, take into consideration all parties involved and all that. So if you have an issue with that report, again, you can challenge it, you can go to court.
Yeah, well, I wouldn't want to go to court in Germany. So, do other countries, do other jurisdictions, can they make decisions?
Of course, but we can discuss about this in more detail after this. Yeah, sure. I'll be happy to discuss with you.
I'm actually, I'm actually interested in taking action. And there are others among us, who would be interested in taking a class action, against this, because we don't want this to happen to somebody else. What we've gone through is horrible.
No, it is true, and as I said, I think it incites sort of to self-censorship also, because in 5 years we don't know what the curators, they would think twice or 3 times before engaging with Documenta. So I mean, the fact that there was this scandal surrounding Documenta this year, I think it has a great impact on how it will be organized in 5 years and how the curators will deal with it. And this is lingering, and this is what I said at the beginning, it goes into self-censorship, it goes into limiting and interfering with someone's freedom of expression. And this is why action is important. Now, I am a lawyer. As I said, my tool is the law, so this is the only direction where I can advise you if you want after this. But for sure, I think action should be taken.
Yes. Okay. Let's talk.
Anyone else for any other question?
Hello, thank you very much today for this presentation. And you are talking about artistic and representing artists, but I have 2 questions actually. How do we define artist? So who is artist? So that because every day, nowadays, maybe everybody thinks that's an artist and they want to express themselves and they think that they are censored. Maybe there is reason for this, maybe there is not reason. But from your side, how do you find that this is an artist and I can take this case? And the other one that I would like to ask is, how do you reach out to artists? I mean, how do they know that you exist? For example, now this is a good opportunity that you are in a very artistic environment, so probably there are creators, so they know that you exist. But if not in these kind of exhibitions, how do you do this marketing thing? These are questions.
Thank you. I think these are brilliant questions. And well, the first one is not very easy, right? Like, what is an artist and what is art? This is a philosophical question. It's also a legal question, and I think depending on the national laws of every country, in general, artists are defined those people that gain from creating art. It is funny asking the questions because while we're working here with Federica, I pointed to her Joseph Beuys. There's a photo of Joseph Beuys with a quote where he says, "Every human being is an artist." And so according to Beuys, we are all artists. According to the law, it depends on what country you are in and also if you gain from the creation of your art. But we at Avant-Garde Lawyers have asked the questions as well because we help artists. And the first question is like, who do we help? Do we help writers? Are writers artists? Do we help? Like, who do we help? Do we help someone that all of a sudden spray paints a building and calls himself a graffiti artist? He just did it once in his life. Do we help him? So in principle, we are very flexible with our definition of art and artists, but in principle, it is a person that has a past in the creation of art, that you can trace it back. You don't have to go to school, obviously, to become an artist. This is ridiculous. It would not be a criterion for us. But if you can show art, so for instance, on our website, and this is how artists get to us. This is going to the second question. Artists come to us through our partner organizations, like big organizations that don't have the expertise to deal with situations like that, and then send them to us, or through our website. And on our website, we have a form for artists, and we're asking for some supportive documents or proof that they are an artist, and they can put links to a blog or to their websites or to their art. So this is how we sort of choose them. But it's a wide question. Do you want to add something?
Just quickly, I think what we also mention is we create this global network. What we mean with that is really we are fostering an ecosystem where we can have other artists help us figuring out whether there's a case that we should look into it. If there's when we talk about definition of art, right, and maybe we can have the support of our artists or some of the lawyers that we worked before and the experts. And so our idea is really to create this ecosystem that doesn't really exist today, where we are the bridge between the lawyers and the artists, and we can kind of connect the two communities. And that really help us also to be more known in the artistic community. And that's why we're really happy to be here in this venue today, because usually our audience are lawyers. We tend to attract the same people also in our day life, right? So I think we're really happy to be able to meet some of the artists and to engage in discussion with them, starting from those forums, for sure.
Thank you.
Do you have any other questions? We are very careful about that. We don't want to take private money or money from governments that are controversial. We have very little money at this point. We have support from the Swedish Arts Council, which is the money coming from the Swedish government, practically. And we have some donations as well. Yes. Just very passionate. We are fueled by our passion. Do you have any other questions? No. I think if no one has any other question, maybe we just can close this discussion here and also continue the discussion, as I said.
Where's Tanya?
Yeah. Thank you very much to all of you. Thank you.